All right, we are live. Just want to make sure that this opens first. And it did. Awesome. Okay, great. Okay, so I've closed that out, but we should be live on YouTube now, and we should have the live going on TikTok. Again, for anybody joining on TikTok, you can click on my bio and go to the link for the YouTube live. It should be right up there at the top. So hopefully we can get all of the audience here together, and that will be fine. Welcome, welcome, welcome. I am so excited to host you today. Today, folks, for anybody joining, we are meeting with Jacqueline Lipton, who wrote this book, Law and Authors, A Legal Handbook for Writers. And this book is all about like laws and authors. So anything that you might query or wonder about in regards to being an author and the legalese around it, this is the book for you. So we're going to be referencing this a lot in our discussion. So if you have not gotten it, it's only like $20 on Amazon, and I highly recommend everybody hold on to this book because it is such a resource, and I have been referencing it constantly lately. So highly recommend. If you are curious, this is aimed at people in the United States. I assume that maybe I'm wrong. Does your legalese experience, does that extend abroad in your experience?
It's a little bit comparative, but the book and most of the work I do is, I'd say, North America, the United States and Canada. I know enough to be dangerous about copyright laws and contract laws in other countries. So, try and answer questions as best I can.
Okay. Awesome. Okay. So just keep that in mind for anybody viewing this. It's going to be angled at the United States. So actually, you know what? Let me change this banner to mention that, because I feel like that's something that I probably should have mentioned in here.
Yeah.
Okay, so should I say laws in North America? I'm saying laws in.
Yeah.
Or laws in North America. Okay. All right, so we're going to add that in so that people understand that that is the case. Okay, great. Well, we're starting to get some people in, so let's just kind of kick it off. Jackie, do you want to talk a little bit about who you are, how you got this background, and how you kind of came to be in this field?
Yes, I would love to. And I would like to thank you, Rebecca, very much for all of the book love on TikTok, because as I was mentioning before we got on tonight, this is exactly why I wrote the book. I realized there was a gap in the market for just very straightforward, basic, accessible law for authors books written for, a professional group of creatives who don't really need the detail of the 400, 500 page negotiating contracts books, that need more than the sort of one page in a craft book about here's what a copyright is. So I am a senior agent at the Tobias Literary Agency. I'm also a law professor, and I teach legal writing at the University of Pittsburgh Law School, where I am right now. Well, I'm not at the law school. I'm in Pittsburgh, and it's hot, and I've got...
And humid, probably.
Humid.
Yeah. It always is.
But my weird background is I started back in college as I liked writing. Then I went into law school in Australia and I became a commercial lawyer. Then I became a law professor. Then I became really interested in intellectual property law and commercial law. And I taught in Australia, in the UK, in the US, and had a midlife crisis and went off to do my MFA in fiction writing at Vermont College of Fine Arts. And I was still having a midlife crisis. So I went to a career coach and I said, what should I do with my life? I like writing. I like law. I don't know that I've got all these kids now. I don't know what my legacy is going to, like all this midlife stuff.
Naturally.
And she said, well, it's not really my job to tell you what to do as a life coach, but it seems, you've got this interest in the law and you've got this interest in editing and creating. Have you ever thought of being an agent? And that sounded really cool. So I went and interned for a terrific agent in the children's publishing field. And then I had my own agency for a little while during the pandemic. And then we merged about 18 months ago with the Tobias Literary Agency. So I head the adult department there. I still have children's clients, children's writers. So I really rep everything from picture book through to adult, and a couple of illustrators on my list. And I'm just interested in all of it. I'm interested in the copyright and negotiating the contracts and contracts with agents, contracts with publishers. Everyone freaks out at the moment, obviously, about AI with copyright, but defamation.
Hopefully we'll be talking about that a little bit today too.
Yeah, defamation, privacy, trademarks, you name it, people have questions about it. So, and I just felt that sort of wasn't a lot of.
It wasn't discussed or like presented in any amicable way.
Right, because when you look at what's on the internet, a lot of it is either just wrong or it's decontextualized, like you just put North America very correctly on the broadcast, because often you'll see something and it's actually been published in England and it's about English law, and English law is a little different, so it is important to have the context right.
Yeah, and there's definitely not a lot of straight information about this kind of stuff that's aimed at writers. Like I started diving into this stuff probably about 2 or 3 years ago, when I kind of realized the extravagant sweeping rights that could be taken away by one of these contracts. I somehow found myself becoming one of those people that they would send these like bad small press publishing contracts to be like, am I being taken advantage of? And I'm a realtor too. So like I started reading contracts and then realized like, oh, anybody can do this. Like I think I used to think that you had to be a lawyer to do it. And then I became a realtor and they had an entire contracts reading class and it all made sense. And I was like, oh, is that all this is saying? Because it seemed like it was going to be a lot more intense than that.
Yeah.
So that kind of helps. Like I think that if anybody's watching and you're curious about it, whenever I say read the contract, that sounds so concerning because of the legalese around those contracts, but the way that you're able to angle them, they're not that complicated if you can get to the core. And not to say that there aren't like words that could trip up the entire meaning of a paragraph, because I think that's where people get scared. And that's where it is good to have a literary agent or a lawyer looking over those contracts. But for sweeping ideas, I do think that most authors can understand what their contracts say. So great. I think that that's something that like this book felt very empowering to me because of that. Like you're reading through it and it gives you a very clear idea of what copyright is, what trademark is, whether or not authors can trademark their pen names, whether or not, copyright law applies to X, Y, and Z, what you do with like song lyrics if you're going to be putting them in your book. Like all of that is in here. And those are the things that as authors, we need to reference on a daily basis. So this book was just such a treasure to find.
I'm so glad. I'm just so happy to hear that. And I hope other people feel the same way, but it's so gratifying because it was absolutely the intention behind it.
Well, and I'm sure it took a really long time to compile. Like, was there anything in there that was just annoying for you to research, or did you pretty much know all of this when you got started?
I think one thing that was very hard for me was to find the voice, because I taught for a long time in college, university, law school, and I tend to lean into this very academic voice. So the hard thing for me was to find the narrative voice to kind of portray it the way I would say it to you.
Yeah, like make it more conversational. Mm-hmm.
And I was pretty familiar with most of the copyright, the trademark, and the privacy law because I have a major research background in all of those areas. Mm-hmm. Defamation, not so much. I practiced in defamation in Australia a little bit, and the law there is quite different to the law in the US. So I had to dig a bit more into that. But that's also, as I say in the book, maybe not the most important thing, because it's actually much less of an issue in the United States. It's very difficult for an author to be successfully sued for defamation. It happens occasionally, but we have a very powerful First Amendment. And
for sure, yeah. Well, and that's honestly great, because I think that a lot of people, I deal mostly in fiction writers, so I assume that's going to be the people who are showing up today are the fiction writers tuning into this. And for anybody who's tuning in, I'll make an extra claim. If you're tuning in on TikTok, which I am streaming this thing, you can click the link in my bio and you can go to the actual YouTube link if you would like to watch it on YouTube instead. But yeah, I think that that's something that like for fiction writers, it's more about like the external, like how do we protect our work from X, Y, and Z, right? Like we want to know about intellectual property protections. We want to know about copyright protections. Obviously, the most recent drama was about whether or not we should be trademarking our pen names. So do you want to talk on that for a minute? Because that was something, did you hear that whole drama?
No, I'm very curious about where that came from, actually.
Yeah, so there's an author, let me see if I can remember her name. Watch me blank, because now we're on live and I'm gonna panic. So there was an author who's basically, she noticed that there were people using her pen name on Amazon to write AI books and pretend like they were her, basically, and like they were tagged in like her Goodreads account and they were tagged on her
Oh,
Amazon
was
account.
this the thing with Jane Friedman?
Jane Friedman, thank you.
Yeah.
I was like, her name, I'm like, she's really big. I
Yeah.
know her name.
Yeah.
I just like, now of course I'm gonna blank. But yeah, so Jane Friedman. So she obviously got a lot of traction in the last week or two because the question was like, well, how do we protect our pen names from being taken over? And the answer is you really can't, as far as I'm aware. So do you want to elaborate on that?
Yeah, no, that's true because you know, as you read in my book,
there's a whole section about this, guys, inside her book.
Yes, there is. I promise I'm not trying to plug the book. You can honestly get it from a library.
I'm trying to plug the book. This is a great resource for people.
But I'm happy just to say it here that trademarks don't affect what we do as authors very much. I mean, you really can't trademark your name. You really can't trademark your pen name. You can't often trademark a book title. Sometimes you can trademark a famous book series title. The reason being that a trademark is an intellectual property right that is what lawyers think of as a commercial source identifier, SOURCE, not SAUCE. I have an accent, I'm sorry. A commercial source identifier that tells you, it's a signal to consumers where a good or service came from. So like the golden arches for McDonald's. Immediately you see the golden arches and a consumer can cognitively know exactly, quickly, what food they're going to get in that restaurant. So it doesn't really work with names because your name isn't really the commercial source of the book. The publisher is where the book commercially comes from. So the publisher's trademark on the spine of the book is the trademark. Your name is your author name. That said, you know, that you can't trademark your name. Yeah, there you go. There's the University of California Press.
Whenever you have the spine of a book and you see the publisher.
Yeah, and that's the trademark because it tells you commercially where the thing came from. So there are laws that deal with what Jane Friedman was facing, but it's not a trademark infringement action because it's not, her name isn't a trademark, and even if she used a pen name, it wouldn't be a trademark. But there are tort laws, TORTE. I have an accent, okay. Tort law, civil wrongs that have to do with making false representations. And a lot of that is in the same statute as the trademark law, the Lanham Act. So, you know, there are actions for making fraudulent misrepresentations in commerce, and saying that this is a Jane Friedman book when it's not is probably a tort, you know, like a misleading and deceptive commercial practice under the Lanham Act, but it's not a trademark. There is an action there, but you're not protecting a trademark in your personal name or your pen name.
Yeah.
If that makes sense.
Yeah, that does make sense. Well, and the way that I always kind of assumed trademark was like, like the visual that attaches to the brand, I guess. You know, like no one else can call themselves McDonald's because of those golden arches. Like you see that and you know what that is. And by my understanding, there's different levels of trademarks. Like you can do like a name, or you can do like an image, or you can do like a color scheme that relates to a name and an image, you know. But overall, it's not really something that authors could follow into because like in my basic brain, like when I was going to simplify this and how I was thinking about it, I'm like, my author name isn't written in the same font on every single book. You know, every book cover has a different style of the way the typography is. So like, even if I keep the same name, Rebecca Thorne, across all my novels, that visual will look different, which means to me, it can't be a brand because like you always see Coca-Cola. And like, I know that that's not the official way to do it, but like, that's how I reasoned it in my brain, you know?
I mean, it's not a bad way to read it, although trademarks, things that are protected as trademarks, don't have to be registered with respect to a certain font or color. So like, for example, I have a trademark over my the term orthography, which is basically the name of my consulting company. And it's a registered trademark, and the word is registered. It doesn't matter I can use any font. But it's only registered for a particular category of goods and services. So for consulting and educational services. McDonald's, you know, there are other companies called McDonald's, but
Yeah.
not in the fast food space. So you are registering within a particular
Within
market.
a particular area. Okay, that's
Yeah.
interesting. Okay, so now when you went through the process of trademarking, if for some reason, like a lot of authors will establish LLCs to basically just kind of work legally inside the US tax wise, right?
Yeah,
To say that we're a business and to make sure that they know that we're legitimized. So if we were going to trademark our LLC name, which usually like I feel like sometimes has like a press after it, like blah blah press, you know.
yeah.
How long did that process take for you to trademark if people were interested in that?
Yeah, so that's a really good question, and it's important to distinguish between the name of the company as like a business name or a trade name from a trademark, because you don't need, just registering your company and your company name is usually very quick and cheap. Quick and cheap. You do it at the local state business office in your state.
Oh,
In
okay.
Ohio, it's like $99, which is mine is
established an LLC, yeah.
Yeah. And you can even register a DBA, a doing business as, so you could be Rebecca Thorne LLC and you could be DBA blah 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 press if you wanted to. That's fine. None of that is trademark. That's just business law registering a company name. It is usually not particularly necessary to trademark that. I mean, because that's just a legal identity that you're using maybe for tax purposes, maybe for legal liability purposes, maybe, as you said, to establish a sort of a LLC persona. None of that needs a trademark. That's just a business name, company name. None of that. You don't need to get into the trademark system.
Right.
If you choose to get into the trademark system, and the reason I registered a trademark for my company was really, I mean, I don't need the trademark, but I was curious. I was curious as to the process of trademark registration in the United States.
I was curious, so I tried it.
Yeah. And I have a friend who was an IP attorney in Ohio, and she helped me, and it's been very eye-opening in the sense that I know when to tell people not to bother doing it. But the American trademark system, unlike most other countries, is a use-based system, not a registration-based system, which means you obtain trademark rights by using your mark in commerce in a way recognized under the Lanham Act.
Oh, that's pretty interesting.
You cannot register it until you have established that.
Have used it.
So in other countries, and I think this is where a lot of the confusion comes from, in Britain, you can just go and register a trademark, and then if you haven't used it within a certain amount of time, someone can say, hey, that should not be on the register. In America, in the US, it's the opposite.
You have to prove it.
But there is such a thing, to comply with international treaties, there is such a thing as an intent to use application. Which allows us to put onto the Federal Trademark Register, here's the mark I intend to use in commerce. Then within 6 months, by the end of 6 months, you have to establish to the USPTO, Patent and Trademark Office, that you have used the mark in commerce as a source identifier for the products or services that you're claiming the registration for. If you can establish that, then they'll register the mark. If you can't establish, you can then extend your period.
And try. Yeah. So what I'm basically getting here, to summarize for people who, because people hear legalese and they tend to just drown out, right? So the basic summary of this last 10-minute discussion is trademark is not really necessary for authors.
Right.
Even people who want to trademark their businesses, because a lot of us have LLCs with that press. You don't really need to be trademarking that. You can just go in and establish it as a legal LLC within your local state and go from there.
Yeah.
So trademarking completely separate from what authors typically need. And again, if you're just joining us, this book will tell you that.
And it's expensive to register a trademark. It's like $500.
And it takes a long time, doesn't it? Like a year, like 8 months to a year. So don't worry about it. Don't do it. Yeah. Okay. All right. So we capped off that because that was something that was coming up in the last couple of weeks. Don't trademark your stuff. Now let's move into establishing a business, because we've already kind of segued into that. So authors in general have obviously, like, whenever you're getting started as a new author, like you have all these grandiose ideas of how much money you're going to make, what you're going to end up doing. A lot of people like the idea of legitimizing that business early, even before maybe they've made any money. So what are your recommendations around establishing an LLC or legitimizing yourself in the eyes of the IRS and the state?
It sort of depends on why you're doing it. Like if you're self-publishing, you probably are going to establish an LLC and you are effectively running your own little business.
Mm-hmm.
If you're traditional, and if you're hybrid publishing, same, obviously, if you're doing both. If you're traditionally publishing, it probably doesn't matter either way. Authors I know tend to have an LLC when they're combining their writing with some consulting and some editing work, and it really is a business. And when you have a business and you're doing various things, it's useful to have an LLC both eventually for tax purposes, but largely just legal liability purposes, etc. But really, and I'm not a tax lawyer and I'm not an accountant, but a sole-owned LLC like I have is a disregarded entity for tax purposes. You may get some state tax breaks. I mean, in Ohio, we had some for new businesses for a couple of years during the pandemic, which was nice because I had an LLC. And I do consulting and stuff like that. But I think it depends on like what do you need it for? I mean, it's not a bad idea, particularly if you do a variety of things, just to have a little company that you can use.
Put under that umbrella.
Right. But if you're just writing books, I don't know that it makes a big difference. You just have to decide when you sign your traditional publishing contracts, are you signing as Rebecca or as your LLC, because you just need to be consistent.
Yeah. Well, and this is interesting because I actually just recently established my LLC, but I was in the traditional publishing space for like 10 years before this point. But I established mine this January. And it was only after I started actually making money off of teaching writing classes last year. Like I did a couple writing classes and got enough money from those that I was like, oh, I should legitimize. And that was around the time that I self-published my first book. So it was one of those things where like I had always had it on my radar, but I didn't personally feel like it was worth the effort to go through until I had a physical check in hand that was over $1,000. You know, like to me, it didn't seem worth the process before that point. For anybody who's curious, if you are looking to establish an LLC, and again, it is that personal choice. Like, do you need to? Are you making money? How serious are you about the business? And how serious are you wanting to be recognized by the IRS? It's not how serious of a writer you are, because you can be a very serious writer and still not want to be recognized by the IRS as a writer. But if you're making a lot of money writing, it might not be a bad idea to put that under that business name to prove that you are doing business as an author, and that's where that income is coming from. But I went through this process and I paid a lawyer, I think like $300, which was probably more expensive than I needed to pay because he did everything for me. Literally, I told him the name of the business I wanted, and he went in my state and established everything. I mean, and he sent me all of the bylaws that I needed, all of the paperwork that I've needed since. But I wasn't able to establish, and I thought this was interesting, I wasn't able to establish a business bank account until I proved that I had a business. Right. So like I went to my bank and said, I want a business bank account back in January. And they were like, what's your employee identity, like your employer?
Yeah, you need the EIN. Yeah.
Yeah, your EIN. And you only get that when you establish as an LLC or some similar business. And then what was really interesting is that I got a publishing contract that was very lucrative a little bit after that. And I went and talked to my accountant because it's always essential to have a panel of people behind you when you're going to be doing something trying to legitimize, right? Like, don't just do it yourself. Get yourself a lawyer, get yourself an accountant. Ideally, an IP lawyer would be great. I'm using an estate lawyer to establish an estate, and he does business law, law here too. But my accountant decided that it was a smarter idea to move into an S corp because I had enough money coming in to make that viable. So it would actually be cheaper in my taxes in the long term. But S corps moving into that is quite a process, and you apparently are not supposed to do it until you hit like income of 50,000 or more.
Something like that,
yeah, something like that. Yeah. So it's one of those things where like these are options that authors can think of, but the first step, if you want to legitimize in the eyes of the IRS and get a business bank account and start feeding the money in that way, the LLC will probably be your best initial bet.
Yeah, and I agree with what you're saying. I wrote the book to be helpful, but one of the lessons in the book is know when to get help. And, I have an accountant behind me. I have a lawyer friend. I mean, I understand the law, but when I need a lawyer, I do have my lawyer friend who, does stuff for me. And you said at the beginning of this, if you're going to negotiate any contracts, have an agent or an attorney. Like if you don't have an agent, there's plenty of literary consultants and literary lawyers, and it's worth the money. I mean, it's not, an agent takes 15%. New York literary attorneys might charge a lot, but I know plenty of consultants and attorneys around the country who charge a lot less. I do a little bit of that work myself.
Do you have any like rough price points of how much that might cost for people watching?
Yeah, I can try and parse this out for you, because like everyone has their own sort of cost.
Yeah, like this vague idea of like what is a scam and what isn't is basically what I'm looking for.
Yeah, and it's also not that it's a scam, but like a lot of lawyers, they are going to just charge you $1,000, like whatever you ask them to do, right? There's a handful in this country of attorneys and consultants, and the consultants are usually people who've worked in contract departments at Big Five publishers and are now freelancing, who will charge anywhere between probably $200 and $400 an hour. It doesn't usually take most of us more than a couple of hours to review a contract. Many of us will then, if you wanted us to negotiate the contract for you, then we'd continue to charge. But I never have done that. I've always just done the notes in enough detail that the person can then go and negotiate themselves. Right. And then compare that to, say you got, I don't know, an $8,000 advance on a contract and you were paying an attorney, I can't do math, 15% would be what, $800, $1,200.
Yeah.
But the agent would be helping manage your career overall. The agent would be helping
offer a lot on the back end that like a lawyer up front probably wouldn't do.
Right. And also the negotiation, if you were then to pay someone like me to also do the negotiation the agent would do, it would be a wash. So it's not ridiculous. Like if someone's telling you it costs them like $2,000, I mean, that's too much. Or $1,000. The Authors Guild, if you remember, has staff that do.
Yeah, that's a great resource. If you are a member of the Authors Guild, and I think Ally, ALLI,
Authors Alliance,
the Alliance of Indie Authors. I think that both. Yeah, I think it's the Alliance of Indie Authors. ALLI, I know. But they both of those places, I think if you are paying their membership subscription, you get access to their legal help, and they have like a panel of lawyers. And actually, that is one of the things. I'm taking a contract class with Linda Camacho, who is a literary agent, and she's teaching me all about author and lawyer contracts, right? Like literary agency contracts. And in that class, one of the things that she actually has referenced is the Authors Guild. On their website, they have like a working sample contract, and then they have notes on the side of the sample contract that go through every clause and talk about like the details of things that you should be looking out for, and like what they consider standard and what like publishers will try to go for, and they break it down clause by clause. So like that was a really I had no idea that resource existed, but if you're looking to compare your contract with a contract that is going to be a good, valid contract, you can literally just go for free onto the Authors Guild website, and they have an entire option for you that you can go through clause by clause. So highly recommend anybody checking that out. Like that was honestly one of the best resources that has come, other than your book, that has come out of that.
The Authors Guild has some great stuff. Yeah.
Yeah. So it was really cool. Thank you. The Alliance of Independent Authors. Somebody in the comments said that. The Alliance, Ally. The Alliance of Independent Authors. So yeah, both of those places are really good resources. There are literary agents that you can also contract out to get that kind of help. And then, of course, a publishing lawyer, and make sure that they're a lawyer in publishing, not a lawyer just in general, because there's a lot of specialties and there's a lot of nuances to publishing contracts specifically that you want to make sure that you're aware of. But kind of like in real estate, like I feel like you can level up as needed. Like you start with the professional who has done a lot of research into contracts, the contract managers, right? And then you move into maybe the literary agents who have done a lot more research and has experience negotiating. And then you can move into a publishing lawyer who went to school for this and is certified to negotiate those types of things. So all of those options I think are good. I think the most important thing to remember here is that you can legitimize in steps, but if you get a hold of a contract, make sure you have somebody looking it over who
Yes.
knows what you're doing, because you can get taken up. I read in your book, was it your book that said that quote? I think your book is the one that said that quote where you work so hard on your book for so many years and then you sign away all your rights with the swipe of a pen. Was that in
I
here?
may have said that because, I mean, I have had several situations where people have come to me either as an agent or a consultant where they've done that and they think, well, a lawyer can fix it. And, you know, once you've given away your rights, it can be very hard to fix it. And, you know, even if one thing people may not be aware of with most traditional publishers, you start with a deal memo and you agree the commercial terms, and then you move to a second stage, which is the formal contract stage. And I've
Yeah.
had people come to me and say, oh, I've negotiated the deal memo, so I just want you to look at the contract. And it's like, you gave away all your rights in the deal memo. So I can negotiate the contract for you, and fine, I can look for red flags and problems in the boilerplate, but I
Like
can't.
everything has already sweeping terms have already been negotiated.
Yeah.
Well, and that is something that I feel like is very interesting and like concerning for people who get on a call with publishers, because these, like indie authors, especially, like a lot of publishers now are looking to pick up indie books. And I feel like a lot of indie authors get on these calls and have the best intentions. And truly, I don't think these presses are all trying to take advantage of indie authors, but there are some that will pitch something that sounds great to you as an indie author, but might not be standard in the traditional world. And if you're moving into a traditional publisher, you should be keeping in standard with the traditional world, regardless of where your roots started. So I think that it's important to kind of really keep yourself in motion there, like always make sure that you're being understanding of what's coming, but also don't give away anything confirmed over the phone. Always say, I will get back to you later once I review these terms, put them in writing for me, and I'll let you know, step back from the process.
I think that's true. People don't realize that that's expected. You know, a publisher may sound like it's all go, go, go.
Not waiting for an answer tomorrow. Like these things take weeks, months if you're doing them properly. So you have time to sit back and get a consult from somebody who knows what they're doing.
Yep.
So give me 1 second. My phone is about to die, and I accidentally just kicked people off because it had a notice about that. So 1 second.
Hey, I can entertain everyone.
Perfect. Go ahead.
With tales from the agenting trenches or from the. I think I will just reiterate while Rebecca's charging her phone, just the importance of taking a breath and taking your time. Even if someone on the phone says, I really need to get this to contracts by next week. I mean, traditional publishers take weeks and months to get the contract done. It's a whole different department at most publishers. So, they'd like to get the deal terms sorted out, but deal terms can take a couple of weeks. That's fine. The contracting stage is going to take even longer than that. So what you want to do is exactly what Rebecca said. You want to have the call and then say, look, can you just send all that to me in email? I'm going to go and consult my attorney or my agent or whoever. And you don't need to say yes on the phone. And anyone who's pressuring you to do that, you sort of have to ask why.
Thank you. That is a red flag up the wazoo if they are asking you to do that. Hands down, 100%. That is definitely something that I was hoping would be brought up. Sorry, I'm getting my life back together.
No, that's right. Get your life back together.
Yeah, right. I need my life back together. No, that is exactly it. If someone is ever putting a time limit in traditional publishing or in self-publishing on something like you need to get back to me in 24 hours, there are very few circumstances where that is legit, and you will always know when they are. Yeah. Like if there's a question, like my publisher, they gave us, but they didn't tell us to get back to them in 24 hours. They said, I'll get back to you in 24 hours. But then we still had time to think about it after that point.
Yeah.
If someone is putting a time limit on it, it's usually a scam to grab money. So run the other way. There's no reason to be involved in that.
And it's funny because it's exciting, when someone's saying, I'm going to give you money for your book, and it's, it's exciting and you want everything to happen, but that excitement is not your friend.
Yeah, that excitement. Well, especially in a world of rejection where you've been told no, over and over, and then you have the chance to say yes. It's tempting. take a break and read the contract, because that's always going to be the way to go.
Yeah.
Okay, really quick, I want to pivot into, I have one question in the comments, and this one, I think I could show it. Oh yeah. What's the worst clause you've ever seen written in or attempted to be written in? And for anyone watching, feel free to drop your questions here.
Yes.
This is the time to do it, because we will be happy to answer them. We'll keep the conversation going otherwise, but we will be happy to answer your questions if you have them. So what's the worst clause you've ever seen written in?
I mean, it's a hard question to answer, because I deal mainly with a lot of the big publishers and the well-reputed medium-sized and smaller publishers, and the contracts are all pretty standard and we're used to them. So I think where I see really worrying clauses, it comes up in some of the newer companies. Rebecca made this point a minute ago. It's not necessarily that people are acting in bad faith, but often a brand new company doesn't know what it's doing. So I'll often see clauses in those contracts, particularly the rights grabs we're talking about, when that company has no track record and no plan for exploiting film, TV, foreign, anything like that. So it's not that if you looked at the clause on its face, and this is where writers get tripped up, the clause looks fine. It's like, yeah, we'd like these sub rights and we'll give you this percentage. But do you have any clue how to exploit those sub rights? And if you don't,
doing anything with them. Well, okay, so hang on, I have a visual here.
Oh, she's got a visual. Let's get the visual going.
I'm like a little nerd. Okay, so when I got my publishing contracts, my family was so confused about what the heck we were talking about, because I have a foreign rights agent who did this one deal for me in the U.S. Like, she doesn't do U.S. deals, but she did this one for me. And when I was trying to explain what was going on with this, I explained it like my little bundle of rights, right? Like I have my little pens, all of my bundles of rights. And when you write a book, you have these inherently, because this is your intellectual property. So you own everything here that is your book. All of this makes up your book. But within these, there's different pieces. Like, this might be your rights in the UK. You know, this might be your audiobook rights in the US. This might be your film rights in the US. This might be your Spanish rights, you know, like if you wanted to translate the book into Spanish in a certain territory. And you have all of these different rights that make up this huge little bundle. And a lot of authors think that it is just one bundle, right? Like they're like, oh, it's one pen. It's one, like, I wrote a book. This is my book. And I will give this to you because I think that you asked for it and you're paying me something I like, right? So they'll just hand over the entire bundle, thinking it's a pen, not realizing that what they're handing over is an entire bundle. And each of these pens could be worth, you know, 10,000 here, 20,000 here, 50,000 here, 100,000 here, depending on how much money and how much hype is around your project. So when you're signing those rights and you're deciding to give away this type of thing, this is something that I always try to remind authors to remember. Like, you have a lot of opportunity to make some money off of your book if you are smart about what you're giving away. But if you hand a publisher everything, they're gone. And you can't get them back usually without some extraneous circumstances.
That's a great visual. I like that visual a lot.
Thank you. I came up with it myself.
No, I might use it because
you should.
It's the whole notion of property. It's a bundle of rights. That's how lawyers talk about it.
Yeah. So anyway, that was interesting to me too, because like I always worked under the assumption that like all rights were like, oh, I'm selling my North American rights. Like it comes with everything. And then I got this foreign agent who was like, no, we're doing absolutely just the US, not even Canada. Like, you know, like she like put in these like things where she's like, I can sell here, I can sell here, I can sell here. This is going to be big in Germany. This is going to be big in Greece. This is going to be big. And so she like had a plan. But again, how are you going to capitalize on that plan? Like, if you're an author without a foreign rights agent, or if you're with an agency that doesn't have those foreign rights, it may not make sense to keep those things close, because if you don't know how to capitalize on that, you know, some books just may not have that potential. But it depends on, I don't know, it depends on an author's unique situation. And I think it's important for them to be aware that those rights are all inside that bundle.
Well, I mean, you know that as a realtor. I mean, I often make the analogy with real estate, and you do real estate. You know, you can sell the entire property, you can lease parts of it, you can lease parts of it for certain periods of time, you can lease the whole thing and say, but you're not allowed in the garage. I mean, it's a thing that you break out the rights.
Yeah, it's property. It's like, yeah,
Yeah.
like you own it. So like you can do what you need. Okay, so I've got some stuff about AI, and I knew that this was going to come up. AI copyright question has arisen.
Yes.
So we've got over here, is AI created material copyrightable?
And that's my boss asking the question. That's Lane. Welcome, Lane, from the Tobias Agency. Hi, Lane. Yes, so this is short answer, no, but it depends on how you define AI created. And this is what Rebecca and I were talking about this last week, but this is what the courts are struggling with. It's always been the case that the American legal system will only grant a copyright to a work created by a human mind. So we've had a lot of case law about all kinds of software generated stuff, like do you go back to the programmer, and there's sections in the Copyright Act that talk about the extent to which a software developer can claim copyright in what the software does. My favorite, and this is in the book, is the monkey selfie.
The monkey selfie, yeah, that's been brought up a lot this week.
Which is exactly the same problem, right? So the freelance photographer dude goes to the jungles, and I think it was somewhere in Indonesia, and he's taking photographs. It might have been Borneo, I can't remember. And he shows a monkey, a really cute monkey, might have been a macaque monkey, how to use the thing, and the monkey takes all these selfies, and you will have seen these selfies all over the internet, and they were in National Geographic, and he's of course claiming copyright. They belong to him. These photos are really valuable, and they're all over the place. And the court ultimately says no, in fact it was the monkey that took the photograph, and so there's no ownership in it. And there's the hilarious thing about that is that people for the ethical treatment of animals brought action on behalf of the monkey, saying that they represented the monkey so that they had custody over the copy. They lost.
I mean, honestly, they should.
The point is, the law is that only a human created work can, the human that creates it can claim copyright. So AI is just a new iteration of the problem that we've always had in the United States.
Right.
And what becomes really fascinating is that you need to really look at the guts of any AI program and really see if you can trace the final product back to one or more actual human minds, or if this really is something completely generated by, I'm just getting a delivery up here, if this is really something generated by a machine. In which case you don't have copyright.
And I think where people are like that video kind of blew up when I made the comment about the copyright. Yes. Right. Like I wasn't really expecting it would end up any other way just because of these court cases that we've seen in the past. But I was excited about it because in my brain, it's like the first block on the building, like in the level of building against AI protections, because obviously we've seen a lot in the last year where AI has become very good very quickly. And it still sucks at long form fiction. Like if anybody tries to write long form fiction, I don't know a single author that can't identify most AI books. Like people have just sent it to us, and I'm in a group where like we were all talking and someone received it and the person claimed it was theirs, but like we're reading it and we're just like, there's no way a human brain would, like, we've read bad fiction by real people and we've read bad fiction by AI, and they're completely different if you look at them from a logistical standpoint.
But think about this in that context. In like 1901, when the film camera was invented, same debate, right? People were like, it's a machine taking the image, it's not a person. And at that point, photography was simply documenting in a way that painting never could. But of course, photography then becomes an art form in its own right. Now, there's still a human behind the camera, but initially photographs weren't accepted.
Yeah, deciding what to angle it at. That is interesting.
Yeah.
Yeah. Well, and I do think that like these are the big questions that are going to come up from a long time. Like, I mean, they're going to be coming up for a long time, I think, where it really does come down to this massive debate of like, how much human input makes it copyrightable, and how like how much can you edit an AI book while it still becomes copyrightable? Because I do know, like, I know authors that are using it where they'll come up to like romance authors will come up to the sexy scene, and they've written that sexy scene 70,000 times because they're writing spice books, you know, and their entire answer, like, they'll go into the chat GPT. Like, I know authors that do this. They'll write me a sexy scene with these context, and then they'll just copy their character, like, and they'll edit their characters into it with like their dialogue and like their quirks, but like the actual physical act is AI generated, you know, like, it's read a lot of romance books and it knows what people like, so it just puts that out, you know. And then you have to wonder, like, well, is that scene technically the author's, or is that just a tool that they're then using, like a camera, to capture a moment that they maybe don't have to think about as hard before, you know?
Yeah, and it is interesting. I mean, I guess this isn't a perfect analogy, but if you take public domain works, like works that aren't copyrightable because they're in the public domain, say because copyright's expired.
Mm-hmm.
Well, if you take a non-copyrighted public domain work like Shakespeare and change a few words, can you claim copyright in it? At some point it does become your own original creation, but how much do you have to do to it? The bar is very low, because Justice Sandra Day O'Connor said in her opinion in the White Pages telephone case, the standard for originality to copyright a work is very low in America, but it's more than nothing.
Yeah.
So you're saying, where do you draw that line? And that courts are probably going to have to deal with that.
Yeah, and that's honestly something I don't really envy them for.
No, but
it's not be a question I'd want to get into. Okay, really quick, I'm going to start moving us down some of these questions because now we're starting to get some good stuff here. So this next one says, are these all rights contracts offered by publishers something you would avoid?
Yes.
So what do you?
See, all my friends are here tonight. I actually know Tamara too. Hi. Anyway.
Love it.
So avoid isn't the right question. Negotiate is the right question.
There we go.
Like, if you're dealing with a publisher who won't negotiate on rights at all and just says, like the whole bundle, no question. But if they say, well, we'd like these rights and not these rights, and you figure it out that it works for your circumstances, that's what an agent does. If you say, okay, well, you can have the rights, but we want reversions if you haven't exploited them within X years of publication. So it's not a question of avoid so much as, are they willing to negotiate? And the ones they want to take and they're non-negotiable on, do they have any capacity to exploit them themselves? Because because I've seen this, people have come to me and said, I've got people interested in film TV in my book, but I signed them to the publisher, and the publisher just thinks at some point they're going to exploit them themselves, even though they don't know how to do it. And that's what Rebecca said. It's just a loss. Yeah. Right.
Yeah. Yeah. And I do think that once you give those rights away, like, I've watched people try to get them back, and it sounds awful. Like, I mean, like, you better be prepared to pay stupid money out the wazoo from a lawyer standpoint, even for a small press that didn't know what they were doing.
Especially from a small press, I think, often.
Yeah. Yeah, especially from a small press. I've seen some nasty, nasty questions there. Okay, so from Promise Press, Ampy flagged this one. What about the corp's tendency to steal now, pay fines later, super damaging for indies?
Which corpse are we talking?
I'm trying to remember when this was. Let me see if I've got anything on Promise Press. Promise Press is on my live, but I'm not entirely sure.
Like traditional publishers stealing stuff from indie, are you saying, or
the corporate? I wonder if this is about AIs. I actually think this might be about AI. Like the corporation stealing from AI, steal now, pay fines later. Like, if they can't, prove that things are taken, maybe. Google AI. Okay, so Google AI. Okay, so Google AI obviously was being sued. They are being sued, and that started in July for scraping data off of our Google Docs files. And of course, there's really no way to prove if they did it or not.
Right.
But the fact that they're being sued for it does lend a little bit of credence and opens up a door to, like, well, what if? Has my stuff been stolen? And that has been a very big concern for the author community in the last 2 months. So I'm not sure what the question is here, but I mean that is definitely something that, like, I don't really know how anyone's going to be able to prove it.
I mean, it's on its face, it's a copyright infringement. Like if you can establish, and there's like the New York Times is suing, that the one you were talking about, the New York Times suing Google, and there's a bunch of things.
It's not even the New York Times. I think there's a different one going on.
Because I know the New York Times is suing someone
Probably
for the
they
same.
are too. I'm sure a lot of people are coming for Google.
Right. And so literally speaking, if you can establish that Google or whoever did it took stuff from the internet and copied it into an AI engine, that's a copyright infringement. That's an unauthorized copy. It's not a fair use. And I do think we'll see these cases, and it's very, very similar to a rash of cases we saw like 10 years ago where, and actually even with the Internet Archive, where, well, it was just there and we weren't making it available to the public unless there was no other option, or unless they already had a copy and this is just a backup copy, or whatever. And those arguments never win. So, I mean, I think courts are fairly clearly going to say this is a copyright infringement. The problem is litigation is expensive. You do have to establish that whoever you're suing did
the thing.
Yeah. Because there was that thing on Twitter a couple of weeks ago where the guy had fed a lot of book text into his program that did the metrics for, like, you know, a romance book tends to have this many thousand words and tends to have this kind of prose and whatever. And he admitted where he had got the files from. So that would have been, if anyone sued him, that would have been a fairly clear copyright infringement. But it is. It's just an unauthorized copy that you're copying into your machine.
Right. Yeah, well, and I definitely have opinions on piracy that don't really relate to opinions on AI stealing things to train AI, you know, because like when I think about like piracy, like I'm kind of known on TikTok for having weird views about piracy because I actually don't have a problem with it. I don't care if my books are pirated. Mostly because I had a video go viral last December that was talking about piracy. And one of the things that everybody, like I noticed in the comment section, like it hit like 2 million views. And in the comment section, I started seeing all these people trying to justify why they were stealing my book, you know, but a lot of them had really good reasons for it. And I was like, I would steal in those circumstances. You know, like some of them don't have access to libraries. Some of them live in LGBT unfriendly countries where like they can be prosecuted if they are seen reading these books, you know, like there's some really good reasons. So
I think you make a good point. And I think that copyright piracy is much more nuanced than people think, because I have talked to publishers when my agency clients have come to me and said, hey, I'm aware that my book's on this piracy website. You know, occasionally when we're talking to the publisher and saying, should we do something about this? They're like, oh yeah, we're aware of that. But those aren't the people who would have bought the book anyway, or could have bought the book anyway.
It's not impacting
the sales.
Yeah, like I made that video, and at the end of the video, the first thing that I said was like, I don't care if you're reading it, but like, can you maybe go and review if you know, like if you have the time, go leave a review, even good or bad, you know, all of them help. And that I think is one of the reasons that video went so big, is because it was a refreshing take from an author who normally the author community is like, no, don't steal our stuff. But I'm kind of over here like, the stuff is going to be stolen anyway. Like, it doesn't matter what we feel. But if someone can get to read my book that would not have had the ability to read it otherwise, and maybe they tell their friends and family about it, and maybe they keep it in their mind and they buy a physical copy when they physically can afford it, that's different to me. Like, piracy is different, but AI comes in and it steals our work without our permission, like piracy, but then they use it to train a device that is going to try and write novels the way I write novels, and me out of the business in that regard. Like, it's not bolstering my career at all. It's just cutting us down. So like, to me, there's like a very clear difference between piracy and AI.
It's dehumanizing in a way that some of the piracy isn't.
Yeah, like, dehumanizing is a really good way to put it. Like, yeah.
And I mean, that there's the whole debate, and the Authors Guild has been front and center in this debate about the potential for AI to put translators out of business, put cover artists out of business, do what you're talking about and try and replace. And, you know, we have the actors, we have SAG-AFTRA on strike, you know, for very similar reasons. So there's this And I do think, I mean, I think there'd be an interesting law review article in comparing traditional digital piracy with this kind of thing for the reasons you're mentioning. And please, no one quote me and say, Professor of Law is really in favor of digital piracy. I'm not saying that. I'm just saying, I'm just agreeing with Rebecca that it's a more nuanced conversation than maybe people think it is.
I feel like people try to make it black and white, stealing is bad, and there are a lot of reasons people steal in every situation.
Yeah.
So to me, that is short-sighted and not understanding the different facets. But when you mentioned the Writers Guild, we have another one from Promise Press. Piracy on Kindle Unlimited. Okay, so you probably are aware about piracy on Kindle Unlimited, right? Do you know about how that's been affecting authors? So basically, to summarize for anybody new, Kindle Unlimited has a tendency when you, and I say a tendency, it happens automatically. You put a book on Kindle Unlimited where it can be available for anybody paying that subscription. So it hits a wider audience. But the second it hits Kindle Unlimited, it is automatically scraped for piracy websites. So you immediately, like the second you put your book on Kindle Unlimited, and if you just put it up for sale, that would not happen. Those books are not being scraped immediately, but there's something about the Kindle Unlimited program that immediately allows it to be scraped. But then what we were seeing happening in February, and still to this day, it's still happening. These authors were getting their Kindle accounts taken down because Amazon found their book on a piracy website and said you're violating your exclusivity clause. And that was obviously a really big issue. So I think this question is asking, are there predictions for Amazon lawsuits from the Authors Guild or indie authors in general? Class action probably would be one, because this has affected many authors that are basically going in and having piracy issues and then being punished for it.
Right.
Do you have any thoughts on that?
Yeah, I mean, and obviously I can't speak for, the Authors Guild, and there's sort of fairly new administration, I believe, at the Authors Guild in any event, and they choose, what they're going to put their resources behind. I mean, clearly there is an action, so it's a question of organization. It's a question of, is this going to be a priority for the Authors Guild with all the other battles they're having to fight at the moment? Yes, I think class action would work very well here if that, if there was organization behind it, because class actions you can really only run when everyone in the class basically has the same claim. But here they do. The big question would be, and I have not looked at a Kindle Unlimited author contract, if they're often those contracts have restrictions in them.
I'm pretty sure this one does. Like, I looked at it and I'm pretty sure. I mean, Amazon is a massively big corporation for a reason. I don't think a lot of us are going to go up against them, even if we're dragged through the coals because of those clauses in the contract. Like, I'm sure there's a workaround if you got a big enough, but in my experience, from what I've seen, the people who have had their accounts taken down, like, they lose revenue and there's really no way to make that back. And I think Amazon is counting on that. But at the same time, they are usually reestablished once the vibe gets big enough. Like, once people make a big enough fuss, they do usually get their account back. It just suddenly, sometimes it loses a couple of weeks or months or year, I haven't heard years, but a couple, weeks, months of their own Kindle Unlimited account, which for some authors is a problem because that might be their only source of income, to which I will say, this problem exists. Try to diversify your income. Like, that's always my advice when people come in to ask, well, what happens if this happens? And, like, diversify your income. And that's not as easy to do, but it's worth the effort, because if you have income coming in from other places and this happens, you will have a little bit more ability to roll with punches, I think.
No, I agree with you. And I mean, this would not be the first time that Amazon has caused or been complicit in, situations that are harmful for the authors that it's giving a platform to. And that's one problem with sort of network effects, with someone being like the only game in town or the main game in town. This is, the issue we're seeing with Twitter. Like, there's no real option yet.
There's no real competition, so they can do whatever the fuck they want.
And that's kind of always been the Amazon problem. And there's several things in the book that I talk about, several little things that have happened to, which are not sort of part of Amazon's grand plan to destroy authors, because Amazon relies on authors, and Amazon
like, it's supposed to be symbiotic, but it definitely skews in one direction for sure.
So I agree. I just think you just can't, that can't be your only source of income. It really just can't.
It really can't. Yeah, not when you're relying on something like Amazon. Okay, so here's another one. You mentioned small presses not knowing how to handle some aspects of publishing. What are ways that someone wanting to start a small press have to make sure that they are operating said press?
Probably operating effectively, operating.
Yeah, effectively operating small presses. What do you think?
Well, I mean, I think, this is one thing that digital technology enables in a way that has never been the case before, 15 years ago. And I think there are lots of reasons people want to start small presses. So you have to think about like why you are starting. Like, is it that just that you're an author and you want credibility? Because in that case, you can just publish stuff. You don't need a small press.
Yeah, you don't need to have a press. You can just
what is the reason you want to run a small press? Because because it's a business, and then you have to distinguish yourself in the market, and you have to tell people what you stand for, and you want to not be promising more than you can deliver, which is the same for any business. So I'd say when I started my business, I went to the Small Business Development Advisory group in Cleveland and sat down and formed a business plan and figured out, in the first year what would be realistic and what would be realistic in 3 years and 5 years. And it really is that kind of thing. If you just want to sort of make money from people's books, kind of like the big publishers do, but on a smaller scale, then you have to go and learn a heck of a lot about publishing to figure out how hard that is to do.
Yeah, and how to market the books properly to the point where they actually become successful enough to make money. Because most small presses go under in about a year or two.
That's why you need a plan, and you need a reason you're doing it, and you need to differentiate yourself. And you probably don't need film, TV, and what books are you going to publish? How many are you going? I mean, some people have done this really well and have come up with really interesting models, and they've stayed small and they've done fun things and they've done good things, but it's much harder than it looks. So I would just say,
yeah, well, and I'll add in like the reason that on my channel, anybody who's been watching me for a long time knows that I'm not very complimentary to small presses because I've seen so many predatory contracts. Yes. So in my opinion, the first step towards making yourself a reputable small press is to get an actual lawyer to help you design a contract. And work in conjunction with maybe a literary agent or something else to figure out what is fair to ask from the authors before you put that contract out there. Because so many people, again, think that it is just one book and they don't realize that it is everything inside that book. And then they take it all. And because someone's so excited to hear the yes, they sign the paperwork and then they end up regretting it later because this small press doesn't have the distribution that they're saying that they do. They don't actually know how to pitch books at conferences. They don't actually know how to go and get a list up, to sell to publishers or to sell to bookstores. They don't have the connections that you need in the publishing industry to make the sales required. So I think that if you're going to be looking for a way personally to operate a small press that I would be impressed with, it literally comes down to where is your distribution going to be and what are you taking from the author in the meantime to try and make that a reality.
Yeah.
So, okay. So here's the next one. With the growing tropification of fiction and marketing, and with tropes being public domain, at what point does writing all the tropes pollute the intellectual property argument, if at all?
Oh, this is good. I'm not sure I'm following the question.
Okay, so basically, this is someone that I follow. So basically, I think that tropification, so fantasy tropes, right? Like the billionaire.
No, I get the tropes, but how does what do you mean by pollute intellectual property?
Okay, so tropes being public domain, polluting the intellectual property argument. I wonder if that is coming down to let me try to figure out how to explain this. If you had a book that was something you creatively wrote and then you were infusing it with tropes to try and make it something that everybody will like because we all like tropes, how much of that could you infuse into that book before you lose the intellectual property?
Oh, no, I see. No, I mean, okay, that's goes back to what I was saying about the Feist versus Rural Telephone, the copyright case from years ago that talks about to own copyright in something, it has to be your own original creation, but the level of originality does not have to be very high at all. And that case was about a white pages telephone book, and that was the case where basically the Supreme Court said you can't copyright a white pages telephone book because an alphabetical listing of everyone's phone numbers is not remotely original. The problem with that case is it doesn't tell you where the bar is. So many cases have said that a Yellow Pages directory is copyrightable because there's thought in the original, in the arrangement and selection of the contents and how it's all set out. Now, that's very far away from this example. The point being that so much of all fiction relies on tropes. You can't copyright an idea. You can only copyright your own fixed literal expression of the idea. So, you can't, like, if you're a Jungian psychologist, like the theory is like there's only 7 basic stories in the human experience,
and
like,
none of us would get to copyright anything at all. So.
Exactly. So it's not a realistic worry. I mean, there's been the odd case in largely theatrical scripts in like the 1920s about this play is too close to this play and comparing them side by side. If you were to put the text of the first 50 Shades of Grey book side by side with Twilight, they are very, very close because, it's fan fiction.
It was based off of that, yeah. Mm-hmm.
Right. And that, of course, was never litigated. And it would be interesting to see what a court.
I honestly kind of wish it had been, because I feel like that would be very interesting. Another example is Cassandra Clare, right? Where she took, that entire book from like the, what was that book called? The City of Glass,
Yeah, the first one.
City of Bones.
I can't remember what the first one was called.
I don't know. That Mortal Instruments book, where she basically like they have like specific quotes from that she like took from another idea, like another book that had been written and published like 5 years earlier or something. And I can't remember what the result of that was. Did she lose that?
I don't think there was ever litigation because she had written Harry Potter fan fiction, and then she plagiarized her own Harry Potter fan fiction when she wrote the first Mortal Instruments book.
No, there was another book series that she plagiarized that I think it went to court. I'll have to look at it and find out. But yeah, no, there was like another fantasy author, once her book became big, read her book and was like, wait a minute, and then found mention of the fact that this author, like Cassandra Clare, had in fact found and read her book like 5 years earlier. And then basically like the Shadow Hunters and everything, like all of those scenes were pulled from that. And I think she sued. But I don't know if it went to court. It might have been settled outside of court. So
they settle. The one that we got as close as we were likely to get to getting a court decision on was the Wind Done Gone, which is the Gone with the Wind from the perspective of the slaves. That's settled. So we had a trial court decision, and the appeal never happened because they settled. But it's very hard to argue that it's really copyright infringement, particularly when you're talking public domain, like you're talking tropes in the public domain. If you had actually taken someone else's well-received fantasy book or romance, that might be something else. But playing with things that are basically very common ideas, as long as it's your own fixed literal expression in your words, that's your own original work. And, you can't sort of lose copyright or not get copyright because your work is very tropey. Everyone likes tropey, as you say in your question.
Honestly, like there's an entire book about it. Yes. There's a book called Universal Fantasies, How to like Leverage Tropes, and I don't have it down here or I would show it, but like highly recommend that book if you have a chance. I can't remember who the author is either, but Taylor something. But it's so good. It's called like Universal Fantasies, and like it's like a bright yellow cover, and like it's fantastic.
But don't worry about it is the answer to the question. Just
don't worry about it. Yeah. Write what you want. And frankly, tropes sell for a reason. So
yeah.
Okay, so I don't think we have any more questions. We'll give like maybe 2 more minutes to wrap up questions if anybody has a chance. But in the meantime, let's just kind of wind down. And is there anything else that we've talked about today that you maybe want to summarize or recap, or is there anything that came to mind that you didn't get a chance to talk about?
Yes, I want to sort of end with what I start with in the book and what I should have started with an hour ago. And I think hopefully the answers to our questions, although we've been a little discursive, the point is don't let fear of legal problems put you off writing, because I think a lot of people, and particularly people writing nonfiction, people writing memoir, people writing historical fiction, people writing fiction that's loosely based on something real, freak out, and they're like, oh, I can't write this because I need to talk to a lawyer before I write this. I can't show an agent this because I'm worried about this. And I often think that's just another one of those excuses, because I'm a writer too. I often think that's just another procrastination technique. And the reason I wrote the book was to sort of demystify all that stuff, so you can just take it out of your mind, and then you can come up with another procrastination technique, like you have to mow the lawn or you have to clean the kitchen, but at least you won't be freaking out, because there are, like, the only thing really that I see that's problematic is when people sign stuff that they don't understand. You will not always get your way in a contract. Contracts are always negotiated, not so much contracts with agents because they're pretty straightforward, but publishing contracts are always, like every contract, negotiated, any sort of big substantive contract to do with rights.
For sure.
Real estate contracts. So don't expect that you'll get everything you want. Do expect that there'll be discussion and that you will understand. And if you don't understand, don't sign it until you do understand it. That doesn't mean you'll always get everything you want. Understand what you're getting, decide if you're happy with it.
Yeah, and honestly, I'll piggyback on that and say that different people want different things.
Right.
Like, one of my lines in the sand, like hands down, I will not sign a contract that has this, is I always have to have a bankruptcy clause in my contracts, because one of my favorite authors growing up, which actually Praseef in the comments is one of the people that got me on this book. It was Nicole Lycan, and she wrote a book called Violet Eyes. And from what I could tell from that entire saga, I was in like 9th grade when I read that book. She published with a smaller press and they went under. And they took her rights with them because of the way that her contract was written. So like, she had to wait for like 10 years. Like, in 10 years after the book, they reverted it back after they stopped publishing her book. It reverted back automatically 10 years later or something. So she literally had to sit on the sequels for that book for 10 years before she could go back into that world. So I remember when the 3rd book came out 10 years later, and I was so excited, but literally, like, she couldn't do anything with that series for 10 years. So to me, it's like, what happens if a press goes bankrupt? That's like my one weird line in the sand that no one else would care about. But I remember that entire saga playing out from 9th grade until I was, 14 to 24. Like,
Absolutely.
So yeah, like, everybody's going to have different, like, figure out as an author where your lines in the sand are, because if this one series is the biggest series for you and you can see spin-offs and standalones and derivative work, then you may want to be more careful about what rights you're going to give up. But if it's a standalone book that you're like, I just wanted to get it out there, you may not care if you're handing the entire bundle of pens to a publisher, and that's okay.
Yeah. Said very well. Well said.
Thank you. I have opinions.
No, I love that you have opinions, because that's why I wrote the book. I want people to be able to read it and think about it.
Okay, so as a wrap up, I don't see any other questions in the comments, so we'll just go ahead and wrap this up. So as a wrap up, if you guys there we go. Yep. If you are looking for a book that talks about all of the different legalese around being an author in honest, true discussion, it's very easy. I use it as a reference book. I started to read it and then I stopped because I was like, oh, it turns out I don't want to read legalese right now. That's okay, because I can flip, because there's a really handy section in the back where you can find exactly what you're looking for and go directly to the page that it's on. This is the best resource for writers, and I think everybody should have one. So please go order this. It is like $20 on Amazon, and having a physical copy has made such a big difference in the last couple of months, when all of these things such as trademark and AI and copyright are coming up, because these things are not going away. And if you're any kind of inclined in it, okay, I'm sorry. My friend is telling me now that I need to be pitching some books too. So I will also add these are my books. Please go buy this one, because it's not getting the love that it deserves, but it's easily better than this one. So go buy this one, Gilded Abyss. It's a science fantasy thriller. And then this is my cozy fantasy series that is going to be republished by Tor. And I'm super thrilled because I just found out that the pages are going to be painted, which is really cool in the reprint. So
that's like a 4-book. That's like a 4-book.
Yeah, so this is going to be a quartet. The first and the second book are out right now. This will be a trilogy because I didn't plot it very well, but only the first book is out right now. But it will be narrated. An audiobook is coming out in November for it. So
wonderful. Congratulations.
Thank you. Okay, so, but yes, please go buy the Law and Authors book, like, hands down, best thing ever. And if you've learned anything today, it's that it's important to always ask questions and not sign anything until you understand what you're signing.
Right. And thank you for having me.
Thank you so much for being here. This was so fun. All right. See you later.
Bye.